All right, I'll kick that back off. Okay, so as I mentioned just before, a misleading and deceptive conduct, if they're in trade and commerce, you are way better off in most situations hitting them with Section 18. Way better off. Only time that you're not is if it's not going to apply. Again, thanks Queensland Justice Association. I would still probably have applied and tried to plead it. I don't think I would have succeeded, but would have tried. Okay, and so a couple of things to note when they're going and they're defining and talking about this particular section is that it has its own series of elements that you go through and prove. But generally, the person bringing the action has a much easier time. They have a far easier time doing it because just the elements are easy to prove. Ooh, harder to read on my slide. I've just noticed. It's going to look very small. I apologize in advance. What? Is that? Oh, it's not really readable, is it? All right. It's not the best. Yeah, gathering it. That's right. It's got the better eyesight. Okay, so a couple of things to note, and I'll talk about some cases, some fun cases. So you've got 5 elements. Strictly speaking, the last one's not an element; it's just an explanation of the test itself. But it's really something that this is left up to the court to do. It's not something that the parties can go through and do. Remember, I talked in mistake about what do they call it? Self-help remedies. There's a self-help remedy. You just, if there's, for whatever reason, that through the check is bounced, go and pick your stuff up. There's no contract, not valid consideration. Self-help remedy. Here, the court has to determine whether this actually applies or not. That's just something to note. All right, so first thing to note is that it's not about information, representations going to another person. It's far wider than that. It's conduct. Intentionally is far broader in scope. And so there's a bunch of things that they do when they're trying to describe and define these things. And also note that most of these cases actually predate the CCA. They're all under the equivalent definition in section 52, I think it is, of the Trade Practices Act. So just make note, if you're reading these cases, that is where that comes from. All right, so there has to be some form of conduct. So one side that you're trying to bring the action, it has to have done something. And that is very broad in scope. It's intentionally left to be very broad. But the second one is that rather than actually being material to induce someone into a contract, it's far lower bar than that. It has to either lead or be capable of leading a person into error. And that person is not even strictly speaking the party that you're engaging in contract with. It could be customers. And that is why this has got so much more scope than common law misrepresentation. So Taco Company of Australia and Taco Bell was from the early 80s, when there was a company that ran a bunch of stores called Taco Bell in Eastern Sydney. And Taco Bell, the American company, wanted to start stores in Australia. And so they're looking at this, and they're trying to work out what the error is in terms of doing this. And again, this was co-pleaded because Taco Bell had a lot of money. They co-pleaded it with a bunch of other things. And the Taco Bell Company of America lost. They lost quite spectacularly. And the reason for that is that, assuming that that's not trademarked wasn't owned by the other trademark, that people in Australia in the late 1970s in Eastern Sydney, what fraction of them would know who Taco Bell were? Stuff all. I'd never even heard of them until I moved to about 10 years ago when I moved to Australia. Never even heard of it. Massive, big American fast food company, never heard of it. And so that's what happened. They said that, look, most people, if you go and ask most people, and again, this is an evidential thing, go and get affidavits from 50 people. I've never heard of Taco Bell, except for that really awesome taco place in Coogee Beach. That's fine. That is an evidential thing. But the court, when they're mapping these things out, said that the conduct has to somehow usually with customers, lead them or be capable of leading them to some sort of error. All right, and the result, the error, the misconception, again, usually it's customers, has to be caused by the defendant. The person you're bringing the action in must have brought about that particular thing. So again, the Taco Bell company, they're trying to argue, the American companies arguing that you guys, through using your logo and your brand that looks just like ours, you're going to lead people into error. And they said, well, we don't care. We don't care. There's no error here. There's no error. They are. I'm getting a look of doom. Yeah.
You're saying that Taco Bell in America tastes different to Taco Bell?
Well, that was it, because they were different entities. The Taco Bell in Australia was a bunch of guys who just started a business, and we want to call it this, and they registered the trademark, and they owned the intellectual property. They had nothing to do with the American one at all, and they'd run it for years, since the 60s. And so when the American one came in, after they got to be big in the 1970s, then they come to Australia and say, hey, this is our logo. I actually had this exact moment in Queensland. There was, I don't know if anybody's was in New Zealand either 10 years ago or earlier, there was a series of pubs called the Cock and Bull, and they were just like the brewery is here. They were awesome. And they'd brew their own beer, and they started in Te Rako Drive, which was my local pub, so I'd go there, and that was the only pub we'd get into when we were underage, so we'd go there and buy $6 pints back in 1995, because earning $7.02 an hour was like one pint, and we paid tax as well, so it was basically 1 hour's work was one beer. Anyway, things you do when you're young. And so I was walking through the back streets of Cairns. I was just walking through there one day, and I come to this pub, the Cock and Bull pub. Oh, wow, fantastic. They've got a franchise here. And I trotted up, and I walked in, and I'm like, what is all of this? And so the trouble is, 99% of people walking through the back streets of Cairns won't get that response. Sure, I was misled, but most people won't be. All right. And there has to be a real and not remote. They don't want to use this 50%. Judges will never say on balance of probabilities is 51%. They try to avoid those sorts of phrases. They really try to not use that type of language. But you do have to prove that there is a genuine chance somebody could be misled here. And again, the Taco Bell guys kind of failed on that as well. And the other case, which was Parkdale and Parksu, they failed as well because it involved furniture companies, two furniture companies, one of whom manufactured high quality stuff, one of which manufactured low quality stuff. And the trouble was, people were aware of the difference between the two. Yeah, sure, some of the names were similar, but these ones are cheap, nasty knockoffs. These ones were high quality. And so they failed in terms of that element as well, being able to prove that. All right. So, zooming into these. 8 minutes. Oh, okay. Here we go. Parkdale's the next slide. The court uses this two-step process for determining whether or not a particular person falls within this audience. And I love this phrase. It's in item number 2. The Australian consumer law has a really low bar to prove. And one of them is that you look on the probable impact of all people in this class of persons. So again, going back to Taco Bell, who's the class of persons? Residents of Eastern Sydney. All right, sure. And we look at those people. What's the probable impact on members of people going in to that restaurant? And we have to take into account the gullible as well as the astute, the smart and the stupid. Who's going to be misled? Is it likely that these guys are going to be misled? Because, there is actually liability you can have if you mislead stupid people. It sounds awful, but the Section 18's got really wide, broad scope. And again, they look at that. When you see this ordinary and reasonable members, in law that's almost an oxymoron, by the way. Usually, when we use the term ordinary test, an ordinary person is usually a subjective test where you take into account human frailty. So, for example, if you are provoked into stabbing somebody after, you're provoked into committing murder, manslaughter, I suppose it would be, when you got really angry because they provoked you, you're really, really angry. That used to be an excuse. It still is an excuse to murder. It gets reduced to manslaughter. It's not a reasonable person test. When he goes to criminal law next year, it's not a reasonable person. It can't be. Reasonable people don't kill people. Quiet contemplation of time. Perhaps, when you're brandishing that shotgun towards me, perhaps I should contemplate leaving the area. No, it's an ordinary person. And so sometimes if you see phrases like that, your law brain, you guys have now got law brains, has to appreciate those terms mean something different. Reasonable person and ordinary person. Reasonable people don't kill people. Ordinary people have all human frailties. All right, and so if they've plopped the two of them together, and that's going to have really broad effect as a result. And so we're going to take into account human frailty as part of this process. But it's not unlimited scope. If people are going to be outrageously stupid, or I think the best phrase is put their head into the sand and actively or willingly suspend disbelief. If me, trying to think, walking through the streets, carried on walking through this pub, knowing full well that they're not drinking their own beer, brewing their own beer, knowing full well that they didn't have the same menu items and like that, I can't really argue that I'm going to fall within the scope of persons like to be confused. And to be honest, the class of persons confused by the cock and bull in Cairns is going to be Kiwis. It's only going to be Kiwis who've been in New Zealand, and the place closed in New Zealand like 5 or 6 years ago. Kiwis of a certain age. It's only a small class anyway. All right. All right, real quickly. Okay, it has to be capable of leading the persons in that audience into error. It's not enough to just make them a little bit confused or to leave them merely wondering. McWilliams Wine and McDonald's. McWilliams, back in the late 70s, I remember Steve telling me this story, he said they introduced a cheap $2 flagon of wine. It was called the Big Mac. Was that going to lead people into confusion? No, it was wine. That wasn't going to, it's not going to leave the audience wondering. There's no connection between that and the burger. Whereas in that Campamar, they actually released a brand of perfume called Nike. That would do more than cause confusion or leave the audience merely wondering. That was clearly going to lead people to think there was some connection or tie-in between the two brands in a situation where there was not. All right, really quickly, there is a causation test. Everything, almost everything in law, not everything, but many causes of action you have a causation step. We will do this when we talk about causation in contract law for breach, but basically you have to demonstrate that they've caused the harm, and there's a series of tests that they use. In contract law, it's usually a simple but-for test. Would the harm have come but for the particular conduct, misleading and deceptive conduct in this case? Simple but-for test. Tort has a variety of other tests as well. It's a bit more complex, but that's not a problem for today. All right. The next slide, by the way, is just a repeat of all of the remedies that we had in the ACL part before, and I've got one more slide after this. Basically, if you manage to take an action under Section 18, you can get the court to do a wide variety of stuff. Whereas misrepresentation, right to rescind, which you may or may not get to use, and if you're co-suing in negligence and or deceit, you can get damages in each of those two things. Whereas here, you can get a wide variety of things. Ancillary remedies, injunctions being one, getting them, the court can redirect goods, can redirect title of goods backwards and forwards, can create orders to make people fix stuff or do what they said they were going to do, essentially specific performance. But they're doing it under statute, not under equity. All right, and the very last slide, before we all disappear and turn into pumpkins, is the difference between the common law stuff and the Australian consumer law. I've talked about some of these. The first thing is the conduct has to be either mislead or be likely to mislead. So if nobody's actually misled, you can still succeed. It's strict liability. If you are responsible, you cause the error, then it doesn't matter if it wasn't your fault. It doesn't matter if it wasn't directly your fault in doing so. Henjo investments and Collex Marrickville, that's an example of the difference in the silence provisions. So in common law misrepresentation, a half-truth, yeah, they can sometimes be actionable, but generally silence is fine. In the Australian consumer law, it's not. If you stay silent about something, going back to this boat. Now, the sale for the boat that I had with Leanne is not going to be subject to the Australian consumer law. Why? Yeah, and so thus, assuming that Leanne is not in the business of selling boats, she's not in trade and commerce. And thus, you cannot rely on Section 18. You've got to do stuff in the common law. And so therefore, any silence about stuff, I say, oh, well, I really want this boat. I'm looking forward to taking it around the island next week. And you're like, oh, okay. Went around the island 9 years ago, but don't think it could make it to the end of the Ross River now, sure. That might be fine at common law. It's not going to be in the ACL. In trade and commerce, you must be much more open about your conduct. So the remedies I had in the previous slide, much broader. Objective assessment, we're going to talk about this difference between reliance and expectation damages. This is actually, not strictly speaking, a good thing. I suppose it is a good thing. It's, when you're doing damage awards for breach of contract, you can get reliance or expectation damages, but I'll talk about the difference between those. Generally, in the Australian consumer law, you need to prove the amount that you've actually lost, not the amount that you were going to make as a result, what you've relied on in terms of that particular conduct. And disclaimers. Generally, you can't use disclaimers to try and thwart Section 18. It's an act of Parliament. Section 18 is going to apply whether you put a term in your contract or not. It's an act of Parliament. There's no... it's not like the Sale of Goods Act that says, oh, if you don't like these, then just put, by prior agreement. If no prior agreement, these apply. No. Australian consumer law says this is going to apply. Section 18 is going to apply to all sales in trade and commerce. And there's nothing you can do about it. And I'm going to leave it at that so everyone gets to go home. Sorry this was a little bit zoomy, but we're going to rely on a bunch of the ACL stuff from this point forward, and that's the stuff you need to know for your assessment. So I'm going to turn this off, and we've still got, we'll end that particular lecture.